All right, so first of all, before we get started, I just want to make sure that everyone understands that what we're providing today is generally information about the EB-2 National Interest Waiver option for permanent residents. However, like any immigration matter, this is very specific to your situation. So while we're providing general information that will give you a good idea of the process and the options, every case is different. So for your specific case, you should always consult with an experienced immigration attorney who can really understand your background and be able to advise you appropriately, especially as to your qualifications or how to present your case as well. But today we are here really to just give you some background and information and some tips, and hopefully you will be able to apply them in your situation as well. So before we also go on to the agenda, I do want to have a few housekeeping items. We expect this session to last about 1 hour, 60 minutes, 50 minutes for the presentation, and we will have live Q&A. So if you do have questions, feel free to enter them into the chat of the Zoom platform. So make sure you do that. If you're asking questions, please note that this is a semi-public forum. People are, here on this forum that obviously are not familiar with your case as well. So make sure that you do keep your questions general and avoid sharing personal case details, because you do want to maintain confidentiality in what you are doing with your legal case. In addition, we will have slides and recording that will be shared to all who registered and who attended. So look for that as well. So that being said, let's move on to today's agenda. So we're going to cover quite a bit today as far as EB-2 National Interest Waiver. First of all, we're going to cover the fundamentals. What is the EB-2 National Interest Waiver? What does it mean? What is the general requirements? Then we're going to talk about the Danazar framework. So this is the three-prong test that the government uses to evaluate a petition and decide whether or not to approve a national interest waiver petition. And we'll also talk about some things that we're seeing. And basically, as you all know, immigration is fast changing. There's a lot of things going on. So we are going to talk about some trends that we're seeing with the government and its policy and how that might apply to your or to NIW case. And then we'll talk more specifically about building a winning petition. Now, of course, when we say winning petition, this is always understanding that there is no guarantee in any immigration case, especially with something like an EB-2 National Interest Waiver, which has a lot of discretion involved on the part of the officer reviewing your application. However, you can do if you prepare as best as you can, you have a better chance of winning the petition. So that is our idea here, is to give you background and information to help you build that winning petition, and hopefully you do get approved for your national interest waiver. And then we'll have some time for the live Q&A as well. But again, as we go along, feel free to add questions into the chat and make sure you keep those questions private, meaning not to give too much detail about your personal situation. So now we'll talk about EB-2 fundamentals. And let me see, let me just hide some of this float. So what every petitioner needs to know before filing. So of course, what is the EB-2 category? So EB-2 in itself can apply in actually 3 different ways. What we're talking about today is the national interest waiver, but the EB-2 category generally is a pathway for those who are either advanced degree or exceptional ability. And within the EB-2 category, if you meet those qualifications, either you can go be applied for through what's called the PERM labor certification process, which is sponsored by an employer, or you can apply for the national interest waiver, which is what we're talking about today, where you do not need to have employer sponsorship, as we'll talk about in a minute. But let's say basically in order to meet the minimum threshold to apply under an EB-2 category, you have to either have an advanced degree, which is either a master's degree or higher in your field of specialty, or if you don't have the specific master's degree issued by a university, either a US or a foreign university, then what you need to show is that you have at least a bachelor's degree a 4-year bachelor's degree plus 5 years of progressive experience in your field. So that also can equate to a master's degree or higher. You also, if you have received your degree, whether it's a master's degree or a bachelor's degree, if you have received your degrees from a foreign university, meaning not from a US university, then you do have to make sure that you have proven that your foreign degree is equivalent to a US degree, and that's by getting a foreign degree equivalency by a credential evaluation service that specializes in doing that. And then the key legal reference there is, as we have here, is 8 CFR Code of Federal Regulations 204.5K. That is what we refer to and what the government refers to as the law regulations that tells them how to adjudicate or decide an EB-2 green card application. If you do not meet the pathway 1 of having an advanced degree, because some professions don't have that, or if you may be in a profession that the degree is not really something that's needed in that field. So you could also look at pathway 2, which is exceptional ability. And within that, there are 6 criteria that the government looks at to determine whether you could qualify for the EB-2 threshold criteria. So basically what they're looking at is if you have an academic record of post-high school or post-secondary education, then that could be one criteria that you could prove by providing your degree or diploma. If you have more than 10 years of experience, then you show experience letters that show that you have those 10 years of experience. If you're in a profession that requires a license or certification, then you would show that as well. If you have a high salary, or if you commanded or received a high salary that is, well, when we say high salary, your salary is higher than other individuals or professionals in your field. So for example, if we say as an engineer, the average salary has been maybe 100,000 and you've commanded 200,000 in your field. So that's a comparison or something to provide to show exceptional ability or be one of the criteria. If you have also, the 5th criteria is membership in certain professional associations. And the membership doesn't have to be high level, but just that you are a member and have maintained membership in professional associations. And then finally, if you can show that you've received some recognition by your peers, other people in your field, colleagues in your field, or by a government, whether it's US government or another government in itself, or if you've received media attention. So it's a little more discretionary or a little more difficult to go pathway 2, but it's certainly very possible to do that if you have 3 of the 6 criteria there. But I will say that there's still more discretion in pathway 2 for the government to say, well, we really still don't think that really rises to the level of exceptional ability. So not just having these 3 out of the 6 criteria, you still have to build your case to show that you are exceptional in some way above others in your field. So what is the national interest waiver? So we define the EB-2 category where you have to meet the thresholds of master's degree or exceptional ability. But now we actually go into the national interest waiver because as I said before, you can be EB-2 based on a perm application sponsored by your employer. But if you don't have an employer that's willing to do that, or you want to be in that process, be in the green card process faster, or potentially get your green card faster, then the national interest waiver is an option that basically waives that perm labor certification. So the waiver in national interest waiver refers to waiving the perm labor certification and job offer requirement that is typical for most people being sponsored through employment, where they go through having a job offer, having an employer that goes through the perm process. So if you are qualified for national interest waiver, that means that you do not need to have an employer. You can apply on your own for your own green card by showing that your work is in the national interest of the United States. So key things to remember: self-petition. You do not need an employer, but the first step that you do, or you have to start, is the I-140 petition that you file on your own behalf. So the advantage of that is that you have control of the timing and the strategy for your case. You're not relying on an employer to go through the Department of Labor process or to determine how and when to apply. You can apply on your own if you believe you qualify. The other key part to remember is that the criteria for national interest waiver, as we'll discuss more in a minute, is based on a case that was decided back in 2016 called Matter of Danosaur, that basically established this three-pronged test to determine whether someone qualifies for national interest waiver. Before that, there were other criteria, but Matter of Danosaur now is 10 years old and actually is still the decision that the government refers to look at whether or not you qualify. Then you also have to think about, in this whole process, the visa bulletin itself. Many of you probably know about priority dates. So basically the timing of when you would actually receive a green card, if you're approved, depends on the time that you file, because there is a queue, a backlog in all these green card categories, and in particular in EB-2, there can be a queue or a backlog. So in looking at your strategy, determining where you are in terms of your status and how quickly you can get a green card, you definitely want to track the visa bulletin, and you also want to be mindful of the timeline that it might take for you to actually get into the final stages of the green card process and receive a green card. So that being said, let's look at the current visa bulletin for May of 2026, or I say current, I know we're still in April, but next month, May 2026, the final action charts for the visa bulletin. So the visa bulletin is published monthly, and it tells us where, or it tells you, if you have applied, where you are in line and how soon potentially you can either file for the final step of your green card process, which is adjustment of status, if you're in the US, or how soon you might actually receive a green card, assuming that you've already applied or are in the final stages. So what you have to know, of course, is your priority date. So your priority date, if you're going the route of national interest waiver, is the date that you file your I-140 petition. So the date that the government receives your I-140 is your priority date. And if your national interest waiver is approved, even if it takes 1 month, 6 months, a year, whatever time it takes for the government to approve the I-140 petition, you will still have the priority date established by the date that it was filed. So if you filed today, April 23rd, 2026, that's your priority date. And now you will need to compare that priority date against the visa bulletin. And also, so basically when you're looking at the visa bulletin, you first want to determine what category you're in. So if we're talking about the EB-2 category, we're looking at EB-2 here, employment-based second. Then you want to look at your place of birth, not your place of not your current citizenship, but your place of birth. So if you are born in China, India, Mexico, or Philippines, you would look at these separate columns here. If you're not born in any of these other countries, then you're going to go in what's called the rest of the world, all chargeability areas. So as you can see, for May, we actually are in a pretty good position for most countries of birth in the EB-2 category. We see that for all chargeability and also for those born in Mexico or Philippines, it is actually a C, which means current, meaning that there is no current backlog. You can either apply for your adjustment of status, the second stage of the process, or if you've already applied for adjustment of status, then you can potentially be approved in the month of May, and actually in April as well. It's pretty much the same. This doesn't always happen. It's pretty good now, but this is pretty recent that we are seeing more of these, that these categories are current. But keep in mind, this can change in June. There could actually be what we call a retrogression. So this C may no longer be current, and we may end up having a cutoff date, maybe cutoff date of 2024. Don't know what to predict. We can't predict at this point, but keep in mind that this is not set and this can change every month, so you need to be mindful of that and track that as well. And also keeping in mind that if you are planning to apply for NIW applications take time. It's not an application where you would, work and complete in a day and then submit it. So you all want to keep that in mind as well. So let's now talk about the Danazar framework. So that is how the government, as I mentioned before, they use the matter of Danazar case to determine how they are to evaluate national interest waiver, every national interest waiver petition that they receive. So what do they look for? Well, the first prong of the Danazar test is substantial merit and national importance. And this is where you would find the most likelihood of an application not being approved because the substantial merit and national importance has not been established in the mind of the officer. So what the government is looking for when we're talking about substantial merit is that your work has real value, that although you don't have to show that you have obtained tons of success already, but you do have to show that the value that you're going to bring is real. It's not something that is, very speculative or marginal. So for example, if you are in the oil and gas industry and you are working in a field of drill, like say a wells engineer as an example. So that in itself, because you're in the field of energy, that probably would have a good claim of having real value, but you have to establish that. Not just I'm just a wells engineer, and that means that, I definitely have national importance. There's more to it than that. But initially, you do have to establish that value to the work that you're doing and be very specific about the type that your work that you're doing. And that also ties into the national importance, because even if your work has substantial merit in that, yes, you're in the field of energy, that probably has substantial merit, but how is that nationally important? How does it extend beyond your workplace, the work that you're doing? What impact that will you have? And so that is where most national interest waiver cases are not successful, because that national importance is not shown. They're not showing that extension beyond your specific job. Now, oftentimes we get clients, potential clients that come to us and talk about, well, I'm in a STEM field, I'm in healthcare, I'm doing these certain things. This is my, I have a degree, a master's degree in technology, in some technology field, things like that. And while that's all great, those are favorable fields in the fact that the government in the past has said we do believe that we have interest in expanding people to work in STEM, science, technology, and engineering and math, or we do want help. We do need expansion of projects in healthcare, energy, AI is a big thing as well. The cybersecurity, different things like that. Those are all good fields to be in, but you still have to be very, very specific in terms of what you are doing, how what you do has substantial merit and national importance. So some strategy tips to look at would be making sure, first of all, that you identify some federal priorities, and federal meaning the federal government, and not necessarily the government itself, but just basically generally what priorities that we can say would be something of interest to the US. So for example, as I mentioned, artificial intelligence, the US government has put out policies and information saying that, we do want to see more, or we want to be the leader in artificial intelligence, research, technology, that sort of thing. We're looking for clean energy. We want to be a leader in clean energy. And not so much now, but at some point, it depends on administrations as well. But, there's different focus depending on administration. So you want to be mindful of that. Healthcare is always a priority under any administration, but you want to show how your endeavor matches or furthers some of those priorities there. You want to also make sure you're getting some concrete data for that. So looking at if you have grants yourself from federal government, that's great. But even even if that's not the case, what you want to do is to also just go out and get that research, that data that talks about what the issues are, what the government reports are to show that there is national interest in that, because there's a lot of information out there. You just have to make sure you hone in on it, not just give general information, but really, if you can, focus on the problem that you're trying to solve in that particular, solve within the federal priorities. Very important, what not to do is to avoid something that avoid an endeavor that just seems like it's going to be a great enterprise because it's going to make a lot of money, right? It's just purely commercial. We're building a product that we're going to sell. Well, that's great, but it's not necessarily showing that the government doesn't necessarily have an interest for your company to be very successful. What they're looking is how is that going to improve the industry as a whole, for example. So you also want to be sure you're not just locally focused. Like even if you say that there's going to be a benefit to where I am, Dallas, Texas, that may not be enough to show national importance. We'd have to show how that success in Dallas is going to extend beyond to benefit the rest of the country as well. And don't describe or don't talk about your work if you're employed, if your endeavor is tied to your current employment, don't talk about how it's unique to your employer or just a certain location. Again, how is your work going to expand beyond your immediate work or your employer's benefit as well? So it's very, as you can see, there's an overall theme, show how you're going to have that national reach. So the next prong now goes, if you've established the national importance and substantial merit, now you also need to establish why your work is critical or your involvement in that proposed endeavor is important and how you're well positioned to move that endeavor. You don't have to prove that it's guaranteed to be successful, whatever that endeavor is, but you do have to prove that because of your background specifically, it is going to have more likely to be successful than not. So some of the evidence that the government looks for, and it again depends on your field. These are very general areas. Some of these might not apply because it's just not applicable to your field or to your endeavor, but typical types of background information about you in particular or by the applicant in particular are things like if you do have publications, peer-reviewed publications, providing information about those publications and especially if they relate to your endeavor, the citations involved with those, it's really important, and the journals that they're in, make sure that they're in journals that are reputable, do have impact factors that you can show. They don't have to be the highest journals out there, but at least show that they are credible journals by providing that backup data, describing and explaining the importance of those journals in itself. So that's very important. If you have a patent or licenses issued for your technology, some agreements for commercial use of any inventions that you have, particularly for those who are entrepreneurs using their inventions or trying to implement their inventions, then that, of course, is very, very helpful towards showing that you're well positioned. If your endeavor and you in particular, or maybe someone you're working under and at work in particular has received competitive grants for the work involved and those grants have mentioned you as one of the researchers or the recipients of the grant, then that's very helpful as well to show that not only that you're well positioned, but also that endeavor has national importance. For those who are entrepreneurs, if you are planning to implement your proposed endeavor through your own business, then you definitely want to show, if you don't already have a track record of producing or working on the proposed endeavor, you definitely want to be providing a very detailed business plan, showing realistically how there's an opportunity, a market for your product or your services, how that's going to create jobs, those kinds of things. Very important to have a business plan for those who are entrepreneurs. For everyone, it's very important to have expert support letters talking about various things, attesting to your background and confirming that you have the necessary education, the experience, the accomplishments that make it reasonable to believe that you can move the endeavor forward. But also those expert support letters can also talk about the proposed endeavor itself and why it is an endeavor that merits that is of national importance and does have substantial merit as well. And then finally, if you have received any awards or recognition for the work that you've done, not necessarily with the proposed endeavor, but something similar to that, just showing that you've had a record of some success and recognition for that success is very helpful as well. Okay. So prong 3, so that is the final test that the government uses when evaluating the national interest waiver. So if you have national importance, great, check that. If you are well positioned, great, check that. But now you still have to make or prove prong 3, which is basically a balancing test that the government makes and wants you to argue why it's more important for you, for this national interest, for you to be involved in this proposed endeavor rather than having an employer go through the PERM process. Because keep in mind, the waiver is of the national interest waiver is waiver of the PERM process. But if the government is going to waive that PERM process, they need to believe that the national benefit of your work is far more important than going through than having an employer go through the PERM process. The purpose of the PERM process is to protect jobs for U.S. workers. So that is a national interest of the U.S., but they need to know to approve the national interest waiver, the national benefit of your work has to outweigh that other national interest that the government has. So it is a balancing test. And for some, it's easier to prove than others. So for example, if you are self-employed or an entrepreneur, it's actually a little easier to prove or to make an argument that it is more beneficial or your national benefit of your work is going to outweigh labor certification. For self-employed entrepreneurs, typically a labor certification isn't really even a great option because the expectation that that someone who's self-employed would go out and try to prove that other U.S. citizens are not eligible for his or her job just doesn't make any sense, right? So basically, if you're self-employed or an entrepreneur, what you just really need to do is talk about how you are unique, of course, in your expertise because you are the person driving that whole business in itself. And again, providing things like your business plan, investor letters, press coverage, all those things just really show, hey, the national benefit is much more than the PERM interest as well. But make sure so you have all of that information, supporting evidence as much as you can. And also it's very much a legal argument as well. So as attorneys, we do develop more of also the legal side of how it is more beneficial for the labor certification to be waived as well. And there's a lot of other legal arguments that can be made for that. So that being said, that's kind of generally how the government looks at it. And before we go into more specifics on preparing or looking at how to prepare your applications or petitions, we also want to talk about some of the things that we're seeing, some questions that we typically get about what's going on with immigration today and how it can affect applications. So one of the things that a lot of people aren't pretty much aware of is that sometimes you can, if your case does not get approved, there's sometimes opportunity to go to court, to sort of appeal it in some way. And what's happened since 2024 is that it has been made a little easier for petitioners who challenge the government's decisions in court, it has been easier actually to get court decisions in favor of you as the person suing. So, for example, now the courts in the past would say, well, whatever the government says, the legal interpretations, unless it's totally wild, we're not going to do anything. We're going to defer to whatever the government's decision is. So it was very difficult to get a court to overturn a decision by the USCIS, for example. But now the Supreme Court has said that the courts don't necessarily have to automatically defer to legal interpretation, so they can actually use their own judgment in some cases. And so it gives sort of another tribunal to hopefully get your case approved if it's not approved at the USCIS level. This is not something really that can be, really used at the time that you apply, but it's something to keep in mind. And as we structure or we look at court case decisions from the USCIS, if a case is denied, we can look at that and say, is it reasonable to go forward, maybe to appeal that as well to the court system. Another area, premium processing is available for national interest waiver. As I said, it doesn't make, as far as your priority date is concerned, no matter how long it takes for the government to decide the EB-2 national interest waiver, no matter how long that takes, your priority date is going to be the same. However, of course, a faster adjudication means that there's a faster timeline for you to actually get your green card. So you want to think about using premium processing. Sometimes people will say, well, was premium processing less likely if you go through premium processing, is it less likely for you to get approved? And in our experience, we have not really seen any distinction there, whether you go through premium processing or go through the regular processing, which could take over a year. It does not really seem to make any difference. So ideally, if it's affordable enough, I would always suggest to consider national interest waiver premium processing. You have a 45-day business adjudication, which could be typically about 60 days as well. Then we have some executive order shifts. Now that's also important as well to consider, always thinking about what is going on with priorities with the government executive orders. So for example, right now there is the pause for certain on certain or almost all applications for people from certain countries, the 39 travel ban countries. If someone is from that country, one of the countries on the 39 country travel ban list, even though travel ban, this has nothing to do with travel, the government is still using that to determine or to hold applications. They'll accept applications for EB-2 national interest waiver or any other application, but even with premium processing, they're not deciding those applications. They're just pretty much putting them on hold. But keep in mind, even if that's the case, it's still, once that hold is done, and if they approve your case, you still have the same priority date. And then finally, you also want to always look at the USCIS policy manual that's consistently being updated. The applicable chapter for citation for the policy manual is volume 6, part F, chapter 5. And that talks about, or that gives the officers instructions on how they're supposed to evaluate national interest waiver applications. Actually, I mean, it's an instruction manual for nearly all of the USCIS cases, but it's very important to look at that and monitor that before you even apply, because changes can happen. It happens fairly quickly nowadays, so you want to be sure that you're looking at your application and presenting it in a way that meets what the policy manual says, so through the eyes of the officer, that you are following all the requirements there. Now, some common RFEs are going to happen. We are seeing more and more of those overall. So having an RFE, though, keep in mind, does not mean you cannot be approved. We get RFEs and they're still approved. It just means that the USCIS the officer has more questions. But sometimes RFEs are triggered by certain things, so you want to be sure that you minimize the possibility. You cannot not guarantee against receiving an RFE, but if you want to minimize the likelihood of getting it, then you want to look at these kinds of triggers that typically are are these common RFE triggers there. So you want to be sure, again, be very, very clear on what your proposed endeavor is. Define your work with very specifically, like what is the work that you do, and be sure to try to explain it in what we call layman's terms, because keep in mind, these officers are not experts in your field. They don't know the terminology, they don't know the science of it is, they don't know a lot of, what you know, of course, because you're the expert in your field, but you want to explain it in a way that they could understand it as someone who is not in your field. But you want to be specific, you want to explain what it is what you're doing, what methodology you're using, how far along are you in the proposed endeavor, what's the timeline. So the more specific you are, the better. If you're going to have support letters, but don't take a template, don't use something, and it's not fill in the blank. And certainly not all of if you have 5 letters, make sure they're all very different and addressing specific aspects of your case or aspects about you, talking about your credentials, your contributions, or why the waiver serves the national interest. Make them very, very specific and detailed and clear enough so that the officer can understand it clearly. If you have publications and you're relying on those as part of your application, this doesn't require that you have a lot of citations, but if you have no citations, or if you're placing in journals that many people don't even read, they're not as reputable, then it's going to be a little harder. So you want to be sure that you frame any citations that you have by outcome, not, basically, if you only have 2 or 3 citations, but they're cited by very reputable researchers, for example, you might want to talk about that. Like, oh, this is one of the most reputable researchers. They've cited my work. That in itself shows some impact that you're having in your field. If you can explain, yes, they may be low in citations, but there has been some significant change because of my research. Some problem has been solved or closer to getting solved because of my research. Another common trigger would be if you were saying you're going to be self-employed or you're an entrepreneur, but you don't really have any record of sales or a record of any contracts or anything. It's just very speculative. That's going to be probably triggering an RFE. So you want to be sure that you provide as much evidence to show, like I mentioned before, a business plan. If you have had revenue, provide your revenue records. If you had good press about your invention or your launch startup and things like that. If you have investors in your business, get letters from them. So again, you want to make sure that you have a lot of documentation there. And then finally, a trigger would be that you talk about, you establish the national importance of your work, of the field itself. Like again, going back to oil and gas, you working in oil and gas, energy independence, that's definitely nationally important, but you don't really tie how your specific work is contributing to that. So you have to really be very clear in your own personal statement, but as well as expert opinion support that says what I am doing actually does tie in to energy independence, for example, how that is. So again, it's very, very specific that we have to be. So now, that being said, let's talk about winning an NIW petition. And so we will talk about your core evidence package, what you need to be sure to include. Primarily, of course, your degree to prove that you are EB-2 qualified, master's degree or higher, bachelor's degree plus 5 years experience, or if you're doing exceptional ability, then you have to also provide those other criteria as well. Depending on what type of field that you're in, what your proposed endeavor is. If it is research-based, publication citations, summaries about the impact of your research. If it's more technically based, patents, licenses, any intellectual property documentation, if you received any grants or funding. Funding also could be investor funding, conference presentations if you've done those things, and invitations to present your work, any honors or awards, media coverage. Try to provide those. Of course, you also want to provide those expert letters that I mentioned. And then your cover letter is really most important. It's got to tell a story, not just list, I have A, B, C, D. You want to tell a story. How do you meet each prong of DANASAR? How does every piece of evidence that you're submitting connect to that national importance? And if there is something weak about your case, it's better to be upfront and kind of discuss, yes, I may not have as many citations to my work. However, these citations, I have been cited by certain like top researchers in my field, or I've gotten a lot of downloads of my articles. You want to address those kinds of things as well. Some things you do want to do is, again, frame your petition as a coherent argument, not just a list of the documents you're providing, but explaining, how do I meet? I do meet the criteria of DANASAR, and this is how I do it. So make sure all of that is addressed in your cover letter. We talked about expert letters as well. You can and should have some letters from people who are familiar with you and your work, but it's also good, and they can have worked with you, or they can be your colleagues working on the same project or the proposed endeavor with you, but you also want to have independent, non-associated experts provide their opinion as well. So you want to reach out to someone who may be in academia or very well known in the field that can talk about your work, but they haven't necessarily been your employer. They haven't worked with you directly, but they're willing to evaluate what you've done and give their opinion about it. And anytime you can quantify whatever you have done so far in your career and the impact that it's had, whether it's generating revenue, whether it's having it, and move the mark somewhere within, for example, oil production. Again, if it's, the production has increased 50% because of what you've done, that sort of thing is something you want to do. Don't use form letters or use someone who's provided you their petition and you kind of, use what they've or try to use, even if they're in a similar field. You definitely want to make sure it's very tailored to you. So don't use form letters or recycle support letters from other petitions. Don't assume that the USCIS will understand the national importance. You need to be very, very specific. And then, having a lot of paper, having a very thick application, that alone is not enough. What you want to do is to make sure every piece of information you're providing is relevant. Character letters, that's not really relevant. They're looking at talking about your work. So you want to be sure you're only providing very relevant documents. And if you file, people can file on their own and without an attorney and still get approved. But if you have if you feel like you want that support, and also in particular, if your field is pretty complex or maybe even borderline or so, you want to make sure that you're working with an attorney who can help you with that, help you bring your best case forward. So if you do decide to work with our firm, this would be your next steps. What we do to help our clients be successful is, first of all, we're going to evaluate based on our experience, based on our knowledge of the law, evaluate your profiles, and let you know if if we don't believe that we're going to have a good chance of success with this, then we're going to tell you that. And we're also going to help you identify what you need to do to help to improve your case. You may not be ready today, but with some work, you may be ready in the future. So we're going to help give you that kind of input and roadmap to see how you can build on that, if you can do those things. But when you come to meet with us for the consultation, make sure you have your CV and any publications and any previous filings or information. If you've tried to apply before, which we sometimes get that as well, bring that so that we can have a good history. Because if you don't get approved the first time, you can apply again, but you definitely want to address what happened in the first petition. The government knows has that information, and they're going to want to see how you're going to address the failings of the first petition that you had. Then, of course, if you work with us, we're going to work with our team to gather, coordinate, tailor each piece of evidence that's going to apply to those Danazar prongs. Timeline can take some time to build and get those evidence, 4 to 8 weeks, depending on how quickly you can provide the evidence. Then we have the petition drafting. So our job is to help you with drafting the expert letters, building that narrative. We draft the cover letter. We'll advise you on the best approach in terms of processing. And then once we file, we are there to represent you, assist you with any RFEs, or track your case. And if there's, again, issues of delay, things like that, we are there to help you with that. So if you're ready to evaluate your or determine whether you are eligible for a national interest waiver, feel free to schedule a consultation with us. So at this point, I'm going to go ahead and see if there's any questions in the chat so far. Oh, I do see a few questions here. Someone has asked, and while I'm answering this question, please feel free to enter your questions in the chat. So how many citations and publications count as good enough a number? So although we talked about quantify, there's no number, that the government has stated that they use. Although there has been previous cases where the government, for example, there was an appeal case many, many years ago. And one of the reasons why that case was denied and appealed, and it's not our case, but something that was published, said that 15 citations is acceptable. That is what a court said. Now, that's not a bright line rule that the government has to follow, but sometimes we will use that case as a backup when someone has a lower number. If they don't have hundreds of citations, you have 15 or more, that's a good rule of thumb. If you do not have citations, again, we don't base everything on just how many citations you have. If you don't have citations, you have publications, then we're going to look at other metrics, or we're going to rely more so on or address that issue in the letters from the experts, or find other ways to explain, like publications. They're good in some ways to establish that you're well positioned because you have published. But let's say you are working on this endeavor and you've just recently published, and you're not going to have citation for that, but that publication is still good because it's showing that at least it was peer reviewed. You were able to publish that. It was peer reviewed. Your research has come along to a certain point where it is publishable. And so you are making progress in your endeavor. So that's where we would rely on that publication as well. So that being said, I mean, citation number isn't necessarily going to make or break your case. It's an overall package that we have to look at, overall, all the evidence that we have to look at. So kind of following up, and then someone has a question of how do we tell you about the quality of our citations? Do we research where our work has been cited and tell you in written format? Well, so yes. So if you have, like, for example, Google Scholar, typically when you get the citations list, you can click and see where each, what papers cited your work. So you being the expert in that, you can always look and see, the people who have cited, if you know of them or know their background, if they're considered to be great researchers, that sort of thing. Or if that work itself, if their work has been very well cited. So let's say a paper cites you have one citation by a paper that in itself, that paper has had 100 citations. So you can kind of build on that, even though it's not my paper, your paper, obviously that paper has had some impact and they've used your work in order to support it. So that could be another way. But in terms of telling the attorney how to do that, yes, you want to give us some of that background, research that, and tell us in written format so that we can incorporate that into the whole package. Question is, what is the expected time from meeting with you until submission of the request? So a lot of that does depend on the evidence gathering. key things. We have to get, all the evidence that you can provide. We will help you to evaluate the evidence as you get it. Expert letters are something that's very important, as I mentioned. So identifying who those people are as early as possible, along with getting their CVs, and then providing information to us in terms of their relationship to you, what you think they are able to say about your work or the national importance, so that we can draft those letters. So that being said, all of those things provided to us, once we've received all of those, and usually we expect to be able to prepare and have the application ready for your review within 8 weeks from there. But again, it does depend on when you submit the information. So it's not so much the time from meeting with you, because if we accept your case, now the work comes in, you need to get us the data. Once you get us the data, that's when we can start working on your case. Based on another question is, based on travel ban for Iranians, are you recommending to apply? And do you know how long it takes for the time to get approval? So that's a great question. And that's what I was referring to earlier about the pause on application. So yes, I still recommend that if you're qualified, the travel ban should not be the reason to not apply. So you should apply if you qualify, because you're still going to be able to establish your priority date. And if the case gets approved, you will be well ahead and you will be in the queue, because we don't know what could happen over the next year or two, even though EB-2 for Iranians is current, meaning that there's no real backlog. It could happen that there's a backlog. So the later you wait, the longer it might take you in order to get your green card, regardless of the ban. So the ban right now is basically saying that they will accept your application. They just will not process it as quickly as they should. So I don't know how long it will take to get an approval, because the ban is still in effect. I will say that with premium processing, typically it's 45 business days to get the I-140 approval. But with the ban, there is no premium processing. I mean, there is premium processing. You can pay the premium processing fee, but they are not honoring the 45 business day requirement for premium processing, and they will eventually refund your fee. So it's just kind of sort of a waste of funds to try to do that at this point while the ban is going on. But yes, so I would suggest, if you are qualified, go ahead and apply, but do expect it will take time for it to be approved or decided. But we don't know specifically, because of the ban, how long it will be. Another question is, if my citations and publications are few, but I have granted publication and several pending. Yes, I mean, can that help? Yes, like I said, if you're going to use cumulative evidence, it's not going to be your case isn't going to hinge on one specific piece of evidence. So you want to bring everything to the table that you believe would support your application. And then we do our best to make that case by providing all of that and painting and showing the government how that all ties in and why it's important there, and how it is of national importance. But having a patent, I would say, is a very good piece of evidence. It's not 100% of your case, but it is very helpful. Next question is, do applicants need to currently be under a specific status and have a specific visa time to be eligible? For example, must be under H-1B or FJ, or then go to EB-2. No, you do not. So national interest waiver is a green card application. It does not hinge on your current visa status. So as a result, people who are not even in the United States can apply for EB-2. We have applied for people outside the US who applied for EB-2 PERM. They've also applied for EB-2 national interest waiver. So your current status in the US really does not affect your eligibility. Now, if you are here on an H-1B or an F or J visa and you're doing the work related to your proposed endeavor, it is very helpful that you have that. But it does not, you're not required to have any specific visa status in order to apply for EB-2. What about dependents? The next question is, what about dependents? Is it a joint application? So the first stage of the process, the I-140, application that is to qualify you for national interest waiver, that is your application alone, the principal person, the worker, so to speak. So you will identify your dependents in the I-140 petition, but your dependents do not have a separate application or do not apply with you until you apply for the second step of the process, which is adjustment of status. So with adjustment of status, your dependents, your spouse and children under the age of 21 are able to apply for that at that point along with you. So yes, dependents are included, but their processing is at a later stage. I know what is the estimated cost. I know it may vary the estimated cost, assuming we apply through our firm, Badmus Associates, and use premium processing. I would say estimated cost would be about 10,000. I will say clearly our fee, we're transparent. Our fee for the I-140 is 6,000. If you're looking at the government fee, it's 1,015 currently, and then you have another 3,000 on top of that for the premium processing fee if you're using that. Next question, do letter writers, I'm sorry, need to be known to us? Like, should it be a dependent letter or should it be independent? You would actually have a combination of both. Usually we recommend at least 4 to 5 letters. And so you may have at least, I would say 1 or 2 that are independent and the rest can be dependent as long as they're good, credible people who know about your work and can speak clearly about that. Do the credentials of the letter writer matter? Who is writing the letter? Yes, you do have to provide their CVs and they do have to show that they actually have expertise in the field, that they they are experts in the field. You don't want someone who is fairly new in the field. You want someone who's established. They don't have to be the top, top experts in the field, but usually rule of thumb, someone who's at least had 10 years of experience in the field and has a good record themselves in terms of accomplishments. So that kind of answers the question about do they need to be experts or can they be general practitioner? So they really should be experts in the field. They're going to be much more credible. Last question I see here is what about publications which are published in past years? If I have a gap after publications and graduations, they worked in a different area. It's still possible to apply so that the publications in your record does go towards whether you're well positioned. And actually, having published, especially if you're in research, it may not be in the same endeavor or same focus, but it does show that you know what you're doing, that you have worked in research and you've been successful enough to have published in the past. So it does help towards that. Of course, again, it's an overall picture. We'd have to look at other things as well. But just because you've had a different area field that you worked in and have publications in another field, it doesn't necessarily lessen your chances as well. So I think that's all the time we have today. I want to thank everyone for attending. We will be, as I mentioned before, sending out the actually, we're going to have it on YouTube, so we'll share that with you as well. So we hope to hear from you. If you need any assistance, thank you so much for attending. Yes, we are going to send a recording of the seminar as well, or the seminar. Thank you all very much and have a great day.